That is right. Well, guys, we are going live here, and John has just told me something incredible. That this is going to be the best IRSMedic podcast of all time. We are going to look at something in a way. John has promised that we're going to look at something in a way we have never, ever looked at something before. And what brings us to our topic today is, of course, the U.S. Tax code and its various terrorist things it does, and creations of incredible strife around the world, and especially for our clients and our friends around the world, our U.S. expats who unbearably face the full brunt of the U.S. tax code. With me today is the great Keith Redmond. Keith is the sort of eyes and ears and pulse and therapist of a way for the U.S. American overseas. Keith is an absolute gem of a resource beyond. He's really developed, I think, one of the best groups around on Facebook. We're really one of the reasons that actually got me back on Facebook, Keith. I can thank you for that. Keith's group, American Expatriates. I got to get that up on the screen so people can see what this is about, because these are the people, I am not affected by this. I live in the U.S. I'm not affected by this. But Keith knows, and my clients are, and what really goes on is insane. I'm just letting John stew a little bit because John's getting fired up, and I'm letting him just get in the background there to get going, because John is fired up right now, and I can't wait to get to that. But this is Keith's group here. We have 12,200 members. Keith, congratulations. So good morning to you.
Hey, good morning.
Are you ready for do you have any idea what's happening today, Keith? Do you know what's going to go down?
Yes and no. I have been a little bit out of the loop because of a close death of a friend of mine. So I have a little bit of an idea, but this will be good because this will also help me with my clients and prospective clients.
Well, what I'm hoping today we accomplish is sort of demonstrate the groundwork that we have laid over the years. To really tee off on that. And that's where I'm thinking this is going as I was going, is that I think that over the years we have done, in this channel, I mean, we have beaten up these issues in so many various ways. I think it's something we have like 300 podcasts on these issues. And,
I think so.
Deeper and deeper. And I think one thing that we've enjoyed doing is we go in this onion deeper and deeper. You think the government is despicable. You think it's terrible. And then you find another.
You go to another level
of that, and so that's what we're here. We're here to help people understand, cope, and maybe advocate. Expose is really the world, and I think that might be the word here. So, with that as my tee off for the great John Richardson, John, can you help us expose what's going on here, our friend, with what the government is doing?
Well, the government is attempting and trying to get a court ruling that would legitimize its exempting itself from the elimination of double taxation clause of every U.S. tax treaty, to put it simply.
Yeah. Now, would this be a summary of what we're talking about? Is that, let's imagine that that there are two parties to a contract, and one party's, and then there's an outside party. Because this is what I was thinking of, John. Well, actually, you know what, John? Let me get into it, because I want to save my questions to the end. I don't want to get derailed. I want to get to how are we going to do this year? Because we have two slides today, right? We have two slideshows today.
Okay, I think so. I think this is extremely important. I think the general message needs to come through, and we'll start with that. But there's three slides. The first one is a very, very short. It's just an outline of what we're going to talk about today.
Okay. Is that the NIIT double or everything double?
No, I think it says there should be 3 PDFs.
Oh, 3. Okay, I had 2. All right, let me get the other one here. I must have. Hang on a second. And
we don't even.
I have to. Oh, here, I can get it up, John, real quick.
Okay,
don't worry, I got it. Yeah.
Anyway, this is going to be quick because I just want to try to keep this focused and organized, which is always the problem with this kind of complexity.
Exactly. That's what we are managing in ways that, and I'm going to have it 1 second here. We'll get it almost there, because we have, and I want to make sure we get everything covered today. Good morning, everyone, by the way. I haven't gotten the comments, and I will. We'll get to some comments in a little bit, but I really want to get to, all right, it's uploading right now, and we will add to stage, and there we go. Move this.
So I'm not.
Hang on, yeah. Sorry, it's there is incredible multitasking going on. You have no idea. Oh, you know what? I need to get. I have to get my stream live on X. Hang on, I got to get this live. The level of. There we go, and look at that. There's our outline for today.
All right, now this is, I think, is extremely important because this is technical stuff, and I don't want to overshoot the mark. Okay, to lose anybody on it, but here's the bottom line. We're going to be talking about the Bruyea and Christensen cases, both in and of themselves, but what they represent and what they mean in the broader scheme of things. There's a saying, you can't see the forest but for the trees. And if you were to ask yourself, what group of people would that be most representative of on the planet? The group of people who can't see the forest but for the trees would be who?
I would say Americans, taxpayers.
Well, those two, but I was thinking of accountants and lawyers. Okay.
Oh, of course. Oh, of course. Yeah. Right. What about
in other words, you go to an accountant and talk about it. I mean, they'll tell you what it says. They have no idea what it means or how it fits into the context of your life, right? And this is a very, very important point, that when people talk about Bruyea and Christensen, they talk about, well, these are somehow, they're net investment income tax cases, but this goes way beyond that. And key point here is that the U.S. government is attempting to interpret the standard tax treaty not as eliminating double taxation, but as giving the United States the right to clearly create double taxation. So what this really is, and I'll explain this more as we go along, is sort of, you can see this as a savings clause to the savings clause of the treaty, right? But anyway, let's continue on. Now, here's our outline. All right, I got 4 parts, or maybe it's 5. I don't know. Here we go. So we're going to talk, first of all, just about the general principle. Next, okay. I think it's extremely important, okay, that for people to understand that this net investment is absolutely an income tax within them. Absolutely, positively.
Absolutely.
It's an income tax, okay?
Yeah, and this is, I think, the shocking thing. It's like, what? Yeah. All right. Yep. Go ahead.
All right. So then we have the whole problem of when the Internal Revenue Code we have on the one hand versus the tax treaty in Part 4. And the broader implications of what they're really up to here, this is absolutely, and maybe they're not even intending it, but eventually people will figure out what the result of this kind of stuff is, and it is absolutely staggering. The government is taking the position that they can exempt themselves from the double taxation provisions of any U.S. tax treaty just by just by simply positioning Revenue Code so a tax credit wouldn't be allowed domestically. This is just over the top.
And it's beyond, right? Yeah, it's beyond.
Even for these people, this is over the top. It's so incredible. But anyway, and understand also that, like everything else, the lack of integrity, total lack of integrity that this exhibits towards treaty partner countries is shocking. And, frankly, I think the time has come for countries to reconsider whether they want to have tax treaties with the United States at all, because clearly the view of the government is that you enter into a treaty if the benefits exceed the cost. In other words, it's like planting flags. In fact, during the Bruyea appeal, the government lawyer, they were talking about reciprocity, right? Canada will allow credit, the United States doesn't. She said, well, of course it's reciprocal. It's just that we're not promising the same things, right? We're just promising a lot less kind of thing, right? Anyway, that's where we're going with this. Okay, so let's go to the, I think what we probably ought to do now is let's go to my blog post and let's go to the section of the tax treaty and see what we're talking about here.
Okay, yep, you got it. Let me get that there, and here, and okay, that was just a
okay. Yeah, you go there. There's the treaty.
Okay, okay.
Yeah. Oh, no, where's that?
I
Well,
have both up. Oh, by the way,
Get on to Article 24. Just get on to Article 24.
by the way, if you are looking for all the John slides, I have uploaded to IRSMedic members for you to join.
Yeah.
Oh, no call this weekend, guys. No call this week. All right,
Okay,
so
Article 4 is what you want. Okay.
So, real quick question, and maybe I'm jumping the gun, gentlemen. So, is the idea with what you're speaking about, John, is that to make these tax treaties null and void, because these tax treaties are to mitigate double taxation? So, is it a question of just not having tax treaties at all? Is that what the
Well,
objective
you
is?
can't have a tax treaty. You can't have any kind of a treaty or agreement with anybody who doesn't interpret it with integrity and with regard to the purpose. I mean, that's clear. And this
Yeah.
is such a clear example of the U.S. I can't even believe what's going on. Go to Article 24. Keep on going.
Article 24, that was fire. There's a quote right there. Hopefully the AI clipper just caught that one, because that was brilliant, John. John, all right, you said 24?
All right.
Here we go.
Yeah.
All right, yeah. So Keith,
now,
here it is.
Now we're going to read this.
All right.
We're going to read this. All right. Now, first of all, the double taxation article here is an exception to the saving clause. So this would mean that Americans abroad would have access to this. Okay. But here's what it says. Now, here's what it says. Now, bear in mind, okay, that under the domestic internal revenue code, there are foreign tax credit provisions, all right, which, some people say eliminate double taxation. I think that's incorrect. I think that foreign tax credits are a way to pay your U.S. tax liability. I mean, let's not kid ourselves.
Right.
By definition, are subject to double taxation. But here's what the treaty says. Now, in the case of the United States, subject to the provisions of paragraphs 4, 5, and 6, let's not get into that because that doesn't have any bearing on this. Double taxation. Now, notice the next word is mandatory. Shall be avoided. Get it? Shall. Not maybe. Shall be avoided as follows. Now, let's watch this language here. In accordance with the provisions and subject to the limitation of the laws of the United States. Yeah. Now that's in isolation, following as it may be amended from time to time without changing the general principle hereof. What's the general principle? Avoiding double taxation, right?
Yeah.
The United States shall allow, again, this is mandatory, to a citizen or resident. Okay.
Yeah.
All right. Good enough for now, right? Now let's pause for a minute and talk about generally the problem of the net investment income tax and why under the Internal Revenue Code of the United States, under the domestic law, you cannot get a credit for that. Now, the reason for that is, if you take a look under the structure of the Internal Revenue Code, the net investment income tax is in Chapter 2A. You see above that Chapter 1, foreign tax credit provisions. In other words, tax credits are allowed for taxes imposed under Chapter 1, but not under Chapter 2A. So net investment income tax, Chapter 2A, normal income taxes, Chapter 1, foreign tax credit rules in Chapter 1. Because net investment income tax in Chapter 2A and not in Chapter 1, therefore, under the domestic U.S. law, no foreign tax credit is available, okay? So here we go. Now let's go back to the treaty text. All right, now here we go again. Now let's read this again. Ready? Okay, shall be avoided. Now it says, in accordance with provisions and subject to the limitations of the law of the United States, as it may be amended, etc. Now, here's the key point. The government is taking the position that because the domestic U.S. law does not allow a foreign tax credit against the net investment income tax, as I explained a moment ago, therefore, that section of Article 24 means that the United States does not have to allow a tax credit when the net investment income tax, a foreign tax credit, when the net investment income tax is imposed on foreign source income. So in other words, as in the Bruyea case, all right, There's a huge capital gain sourced in Canada. It's Canadian source income, but because he's a U.S. citizen and because it meets the definition of investment income in the United States, it's subject to that 3.8% surcharge, that toll net investment income tax. He paid tax on that in Canada. He paid more tax in Canada than he paid in the United States. But what the United States is arguing is that he cannot use his tax paid in Canada to offset the 3.8% net investment income tax. He could use it to offset the regular capital gain because that's under Chapter 1, but not the net investment income tax because it's under Chapter 2A. So the question here is whether the treaty should be interpreted to say, Mr. Bruyea, of course you get the foreign tax credit because the treaty says it applies to income taxes, which this clearly is. You paid tax on that in Canada, and therefore, according to the terms of the treaty, you're entitled to use the Canadian tax as a credit against the 3.8% tax. Got the picture?
I got the picture, John, but and I think part of it, I think part of it sounds reasonable, doesn't it? Like, well, look, we have these statutes and it's not the thing, right? I mean, the government isn't coming up with nothing, right? They have a
That's right. So let's consider how that was considered in the first court. And the government, of course, took that position. Now, part of the problem is, what is that supposed to mean? What we're dealing with is the meaning of the language in accordance with the provisions subject to the limitations of the law of the United States. Does that mean, should that language be interpreted to mean that they can come in and actually deny a tax credit in its totality? Or does it mean that the way the tax credit is calculated is based on, to use the language of the lower court, the computational rules of the Internal Revenue Code and perhaps timing rules, right? Et cetera, et cetera. In other words, there's a difference between taking the position that that language can deny a foreign tax credit altogether and taking the position that, well, the meaning of that language is that in granting the foreign tax credit, that the rules for granting the foreign tax credit are the basic U.S. rules for granting a foreign tax credit, right? So the issue is, can they use that language to deny the credit at all? Now, where I'm going with this is as follows, right? That, this has somehow become a localized net investment income tax fight, as though that's what's really going on. If the government can win on this, if the government can prevail, and if the courts rule that the language in accordance with the provisions subject to the limitation of the law of the United States should be interpreted to mean that the United States can deny a foreign tax credit altogether, right? The question is that consistent with the tax treaty or not? Now, certainly Canada's position, they weighed in on this, is that that's idiotic. Well, they didn't use that word, but, clearly he should be allowed the credit. Canada would have granted the credit, etc. Now, the government's argument on this, the problem with it is that you would agree that these provisions in a tax treaty have to have some meaning or they wouldn't be there at all, right?
correct.
So I think the first question is, can you interpret the meaning of it so that it has no meaning, right? In other words, that the United States is not bound to do anything. Because, and this is where I'm going with this in a bigger...
Beautiful, yeah.
All the United States has to do, if they win on this, is an end run around tax treaties.
Yeah.
All they have to do is, create their taxes outside of Chapter 1. Create another Chapter 2A tax. Or another thing they could do is just simply enlarge the meaning of net investment income tax so that more and more taxes are now called net investment income taxes, right? Without even creating a new chapter, this sort of stuff. Now, somebody might say, John, that's crazy. That's conspiracy theory. Well, if you go to my blog post, I've shown you 2 instances where they're already discussing it. Right?
Amazing.
All
All right. I think
well.
all right. I think I could recap and tell me if I'm right. And this might be for you, Keith. Okay, so this is kind of what's happened, right? So as I highlighted this text right here, elimination of double taxation, right? And
Yeah.
as we go through this, okay, great. Double taxation is limited, but essentially what's going on is the government says, aha, not so quick, because we have a little trick for you. We segregate our code like this, and because we segregate our code like this, we don't have to give you a credit. Because we have this structure here, we can ignore this.
We go to the treaty to determine the meaning of income tax, right? Now, if you go to Appendix A in my blog post, I reproduce the language, making it very, very clear, okay, that the net investment income tax is an income tax within the meaning of the treaty. There's no ifs, ands, or buts about it.
There you go. Right there you go. You see that? Taxes on income and capital. That's what it applies to, right? Okay, yeah. That's what it applies to. Boom. Elimination of what? Taxes on income and capital. So what does the IRS say? Well, obviously what we're going to do means the opposite, right? That obviously means the opposite, because we're going to make and I think that's what they make this own internal structural argument that says, well, because in our own definition, we're just going to define it we're going to define income tax in a way that's.
But Anthony, go down to Appendix B. Go down to Appendix B. They cannot. If you look at the structure of the code, it's impossible, because subtitle A is income taxes. There's the income tax.
Oh,
right there. Subtitle
A.
Income tax. And it includes Chapter 1 and Chapter 2A. That's my point. There is no doubt that this is an income tax within the meaning of the tax treaty. No doubt about it.
Oh my God. That is okay. This is really beyond them. So you're saying it's not an income tax? Why?
I'm not saying it, Anthony. I'm looking at the Internal Revenue Code is saying it. I'm not saying anything. That's what they're saying.
The IRS says it's an income tax.
Well, the Congress says it's an income tax. How do we know? Because look, we see that. Look at that. Look at this. 26 U.S. income taxes. And now
there we go. Let me get that up there. We'll do a little effect there. Income taxes. There's a high level, our 60s music video effect there, right there for those of there you go. Enjoy. Oh my God. And they're beyond. All right.
Well, what they're doing, another way of looking at what they're doing is they're saying their obligations under the tax treaty are limited to their obligations under the domestic law. Well, if that's the case, then the whole tax treaty is pointless.
Right. And that's the whole thing, because your domestic law can always undo what a tax treaty is. And now, what is the higher law of a land, a treaty or an act of Congress? And well, I would think
that's not even the issue here. That's not even the issue, interestingly. Okay. I mean, for a number of reasons. Okay. Which are probably too technical to get involved in this particular podcast, but suffice it to say, I do not see, sure, we can say under the supremacy clause, the legislation treaties have equal weight, but the point is there was no attempt whatsoever to override a tax treaty in this legislation, which is the generally required predicate, okay, to be able to do that. That was mentioned briefly in the lower court hearing in the Bruyea case. That was not an issue on the appeal, and nobody has raised that. Okay, the issue is whether, when you read the tax treaty itself, the issue is not even, by the way, okay, whether the credit is allowed under the treaty. Everybody agrees the credit's allowed under the treaty. Everybody, even the U.S. government would agree to that, but for the language that says they can opt out. So the question is, do you interpret the language in accordance with the law of the United States to allow them to deny a credit altogether, right? That's the issue. The meaning in accordance with the law of the United States. Does it mean a blanket denial of a treaty, which would make the elimination of double taxation clause completely meaningless? Obviously, right? Or does it mean that in accordance with the law of the United States would mean the procedural mechanisms, possibly timing issues, et cetera, et cetera. So that's what the fight is about here, right? Now, in the Bruyea case, the lower court said, no, government, we don't agree with you. Okay, we think that the meaning in accordance with the law of the United States has to do with how the tax credit is calculated, et cetera. In the Christensen case, in the lower court, the judge agreed with the government and said, well, no, the meaning of in accordance with the law of the United States is that they can deny the credit, but there was another provision, right, of the treaty, where they were able to sort of shoehorn this in. But the real issue here is on a very basic level, can the United States deny a foreign tax credit under conditions when the tax treaty not only would allow it, but the word is shall, would compel it simply by saying, well, in accordance with the law of the United States, we're able to exempt anything we want from the treaty.
That's what it is, right?
That's the real issue here.
That's
now,
really the real issue.
Critical, because this is not about, once you understand that's what the issue is, this is no longer about just the net investment income tax. This is about ability, giving a judicial sanction, if you will, a judicial green light for Congress to basically put, to basically design tax laws so that foreign tax credits are no longer available under any circumstances. This is a declaration of war on American citizens. It is an outright declaration of war.
It is absolutely, John, this is what I think the courts are. It's a war, and who is the person deciding it? Because this is what I think the courts are basically going to do. Does the word of the United States of America matter at all to anybody else? Do words matter? That's actually what we have. That's actually what this is. Do words matter? And that's what that's I think that's really what our battle's been against. Do words matter? Because we have a government that always finds these words that means the opposite of what they mean. Well, and double taxation, well, that means double taxation, obviously, right?
It's clearly Orwellian. I mean, if the government wins, then the elimination of double taxation language should be changed to the creation of double taxation.
Right.
That's what it should be changed to. But also, there's so many issues here, having to do with the intent of the treaty and, blah, 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 blah. But what they're really saying is Canada's obligated to provide a credit, but hey, we're the United States. We're not obligated to do anything.
We do what we want. We are supreme rulers. I think there's a lot of reasons for that. All right. Well, should we?
Anyway, that's the bottom line. We can run through the slides quickly if you want, or we can just open. Maybe we'll run through the slides quickly.
Yeah,
Pick up a few other points on this. No, you want the other one. You want the other one first.
Okay.
Yeah. Here we go.
Okay.
All right. So this is. Let's run through this quickly. The core conflict. Well, I think I've already explained this. Okay. We have the 3.8% net investment income tax. But I want to emphasize that's how it's defined today. They already have proposals to increase the scope of net investment income tax. Why not just convert all income to net investment income tax?
Yeah, right. It all is right. Just do right. There's no right. There you go.
If they converted all income to net investment, then it would just be like it'd be a 3.8% charge on all income. They might do better that way.
Oh yeah. By the way, that is your 3.8%. That is what your Republicans promised to get away with, repeal with their multiple efforts to repeal Obamacare where they weren't in power. Now that they've had power, they make sure it's there. So it's always a fun thing there. And of course, Donald Trump had his promise to end double taxation for Americans overseas. And we have other things going on. We had other things to get to, I guess.
This appeal is inconsistent with that. But I think what's worth noting here, Anthony, is this. We're living in the world of tariffs and the hatred of the foreign. Obviously, okay, from a U.S. perspective, by disallowing the foreign tax credit, this is just a 3.8% tariff on investing in foreign financial products. It's a tariff against the American people.
Oh, yeah.
The same way that an import tariff is it's a tariff.
It's an import tariff without having to import anything. It's great. I mean, really, they're really lazy too.
Spending money on things that are foreign.
Right.
That's what
there
a
was no
tariff
heavy
is,
lifting
right?
involved. It was just hey.
So
Right.
it should be viewed. It should be viewed as a tariff, and instead of calling it a net investment income tax, I think the title should be changed. The tariff on foreign investing.
There you go.
That would be more accurate, right?
There-
But what it does is it creates double taxation.
Yeah.
Why? Because you're obviously paying taxes to the other country. By the way, whether you're an American or abroad or not, you're going to be paying some kind of tax, whether it's an income tax or withholding tax. But you also have to pay the 3.8% net investment. It's pure double taxation. Pure double taxation. Next. Well, okay, I've explained this already. You know, the question is which prevails, the internal revenue code or the treaty. Next. Yeah, I explained that already. I mean, it's interesting that both Bruyea and Christensen won on the issue of whether there was a foreign tax credit, but they won for different reasons. The core conflict is, right, in Bruyea, the court is saying, oh, no. This, you know, you cannot have a blanket denial of a foreign tax credit in the context of a treaty that not only allows it, but compels it through the word shall. But in Christensen, the judge said, of course we can have a blanket denial of a foreign tax. We're the United States. We don't have to do anything, no matter what the treaty says. Next.
Now, John, and I didn't realize this, but oral argument was on the same day, right?
They were back to back, okay? And the Bruyea case was argued first. I think the reason the Bruyea case was argued first was because that dealt with the core issue that we're talking about today, the interpretation of the laws in accordance with the laws of the United States. You see, if the court decides that the lower court was right in Bruyea and the government is not allowed to interpret it as a blanket denial, then the issue in Christensen goes away completely anyway, right?
Oh, okay.
So, you know, I think it was smart for them to hear them. And by the way, the Bruyea thing was almost an hour of argument. The Christensen thing was very short. It was like 15, 20 minutes.
Okay.
You know, they were back to back. But the reason the Christensen thing was short was not because the issue wasn't important, but because the main issue
was already discussed. Yeah.
Part of the treaty had been argued in Bruyea. Anyway,
okay.
Next.
And that what circuit is this in? What circuit?
Oh, I can't remember what the
was it 11?
It's some kind. I can't remember the name of the court, but it's not. It's the United States Court of Appeals for something or other. But anyway, so here's the issue. You know, the government stance. Look at this. Empowers the U.S. to completely deny the foreign tax. Empowers it. Taxpayer defense. Well, I've explained this already. Those are two, you know, conflicting view. Next. I don't want to get into this particular issue. When the Christensen case came out first, and people were immediately saying, well, you know, treaties with the 3-byte rule, which the 3-byte rule is a way of resourcing U.S. source income to the foreign countries, nothing to do with foreign source income per se. Anyway, I think it's beyond the scope of our discussion. The issue is not the 3-byte rule. The significance of the 3-byte rule is that it creates an independent foreign tax credit that's not in the Internal Revenue Code. That's why it's important. In other words, its existence is important because it's evidence of a treaty-based foreign tax credit, but the terms of it are not important because they really don't apply in this case. Next.
Got it. And the 3-byte rule. There you go. That sounds like a lot of fun.
Okay, we can move beyond that. That's pure speculative. Next.
Yeah, the whole,
you know, some of this is based on, you know, I did a podcast or an X Spaces with somebody who actually went and heard the live case. He had some comments about the judges. Anyway, I will say this, that, you know, having heard the oral argument, I was really impressed with the quality of the judges.
Oh, nice.
Yeah, I mean, they were very, very good. They were very, very sharp. We'll see what happens. Okay, next. The lawyers, same lawyer, London-based lawyer, arguing for the taxpayers, was good. The government lawyer, you know, I would not want to be a government lawyer. You just have to deal probably with what they throw at you on any given. The thing is that, I mean, the kindest thing you could say is she was really out of her depth. Okay, really out of her depth. But
Okay.
anyway, I feel
But yeah,
bad.
but you got it right. You're dealing with you got to deal with, right? So
You got to deal with
it's
what you
not
gotta deal with.
it's
This
not
is
necessarily a comment on her skills. It's comment on her circumstances.
circumstances.
Yeah.
Anybody who was throwing that case, here, you deal with this.
Yeah, right. I wouldn't do well. I wouldn't do well.
Nobody. I wouldn't do well either. I mean, I spent a lot of time thinking about this, so I can talk about it more time than I'm sure she has.
Yeah.
It's very difficult stuff. I feel for her, but the reality is that it wasn't great. Okay. And understandably why it wasn't great. Nothing to do with her. I'm sure she's a
Nothing right. Absolutely. Yeah.
general, right? But okay. Yeah, okay. Dissecting the government. I would agree with the first that they're saying treaties can override statute, but here, not here. The airplane would double dip.
There are-
This was unbelievable. Oh, this was just part of the problem, right? We have the myth of expat taxation. So during the argument, she claims that. Now, bear in mind, this is foreign. This is not earned income, right? It's foreign source investment income. And what she's saying, she actually said this, that foreign source investment income be excluded under the foreign earned income exclusion. Therefore, people were double dipping. I mean, that's just a flat out misstatement of the law.
Oh wow.
Terrible, terrible.
Yeah.
And then, the absolute lunacy, well, which we hear all the time, take it up with the United States if you don't like it. Hear the government lawyers saying, well, take it up with, Canada competent authority, get them to change the treaty. Just ridiculous stuff. Detached from practical diplomacy. Yes, I would agree with that. Okay. Next. Well, there's my language.
It's a tariff. Yeah.
Yeah, these things are tariffs, right? If we look at things like PFIC, CFC rules, all these foreign rules, they really should be thought of as just tariffs, right? Punishment for investing in the foreign. And that's what it is, right?
Yeah.
Next. Well, there was some discussion in the case about how Canada made it clear they would have given the credit, the U.S. doesn't. The thing that was really disturbing about this was the government lawyers claim that was reciprocal, that reciprocity did not. And I think logically it's correct that reciprocity means you agree to something and I agree to something. I mean, let's look at what Treasury understands reciprocity to be. Why don't we look at the FATCA IGAs? These are reciprocal agreements. It's just the United States.
Oh, right. Yeah. Yeah.
Right.
The
same thing here. I mean, this is just a bunch of fantasy, right?
Oh, okay. All right. So word games. More word games. More words don't mean what they
mean. I don't know. I mean, I'm not the best person on this because I spent so much time. I mean, that's I've written out.
Well, we'll go. We can ask Keith. What do you, Keith? Now that you heard this, Keith, you have any feelings on and maybe people, and I'll get to some questions now and see how people what they think on this.
Yeah.
Oh, the one thing I wanted to mention, John, because I listened to your interview with the attorney who was at the oral argument.
And he wasn't a lawyer.
Okay. He sounded like it. Oh, geez. All right.
Did you want to ask me a question?
He's one of these really intelligent lay people.
On him, Anthony. That's an insult to call him an attorney. Why would you do that?
That's right. I know, right? No, I mean, that's what we love about this movement is there's a lot of brilliant people, and I know a lot of. I know.
Yeah. No, Tim's been in this for years and years. But anyway,
well, Tim said something. He said something on that. He goes, someone should, because they're claiming that, hey, we're not going to offset this tax because it's a Medicare tax, really. And so when you guys were discussing, he said, yeah, someone should really look into whether or not the money from the NIIT goes to the same place as the income tax. So while I was listening, I typed it up. I'm like, yes, it sure does.
I mean,
the same place.
I think these are two. Oh, actually, that's a great point. You remind me of Anthony. Thank you for that. I mean, look, first of all, this is clear. The revenue apparently, I mean, I've read the same thing. The revenue apparently just goes into the general treasury stuff, like taxes in general. That's interesting.
Yeah. So I have a question regarding this,
go ahead,
John.
Second, remember that we're talking about this is a tax to fund Medicare for resident Americans. Americans
right.
Get
so when is a decision to be rendered on this, where people need to keep an eye out for?
No idea.
No idea at
No,
all.
well, right. Well, Keith, thanks for that because you're bringing up a really great practical question. Well, what do you do now? Because
Well, that's the thing.
right?
Yeah, you're right. Exactly. Because it certainly inhibits anyone in maybe some of their choices until they decide, until this decision is rendered on what you're speaking about.
Well,
You
I
see
don't
what I
think
mean?
so, really. I mean, I think in France and Canada, you take the position the tax credit's allowed because that's what the courts have said.
That's what I'm
Right.
going to do. I mean, that's what we do.
Right. But then if you're in other countries, you just kind of have to, wait and see.
You work with your advisor on this thing. I mean, there are other arguments over the years, and different tax preparers behave differently on this. Right?
But this is. But I mean, let's just stop and think about how insane this is. Is that you can't really, because I was just thinking, no, we'll do it anyway. But not maybe everyone. First of all, you're going to an attorney to get them read the tea leaves. You need to do that, and now you have to listen to this guy to say, yeah, don't worry about it. Just do it anyway. What? I mean, that's the thing. It's like maybe you believe me, but maybe like what, I don't want to take that risk, so I'm just gonna pre-surrender. And then as these go along, maybe the government is ultimately proven incorrect. But now you limited your time to claim a refund, or it's no longer worth it.
Right.
I mean, these are just this is the end, right?
Right. And as you know, gentlemen, I deal with a lot of people who are contemplating whether to enter or re-enter the U.S. tax system. And what you guys are talking about right now is certainly inhibiting them of even considering doing it.
Ooh, good
You see what I
point.
mean?
Especially if someone has a lot of especially if someone has a lot of investment income.
Well, let me tell you where the
right?
problem on this is. Look, first of all, there is a threshold which is not hugely low before this kicks in. I don't remember what the threshold is. It doesn't apply to $100 of investment income. But practically speaking, where this is a problem for Americans abroad is on the sale of a principal residence.
Oh yes.
Because let's say you've lived in your house for whatever 40 years. $1 million capital gain. That's where this is a real problem. Okay, to contextualize this for anybody who's listening to think this doesn't apply to me, you're wrong. Okay, it applies to you even now, right? On this, this is a huge issue. Look, I do not believe. I don't believe that there's going to be a huge wait for this decision.
Yeah.
But
by the way, how was I didn't read it, but maybe John, did you read the amicus briefs for Democrats abroad? Did they? How was that?
You mean the most recent? Oh, I don't think they did an amicus for this.
They didn't do one on this. No kidding. No kidding, huh? I guess
I don't know for sure. I think they did not. I think there was only one amicus from Professors Shaheen from, I believe, Rutgers and Rosenblum. He maybe, I don't know. Anyway, affiliated with Kaplan Drysdale and NYU LLM program. They argued very, very strongly in favor of that. Yes, there should be a foreign tax credit. I mean, they really took the government's argument apart. You'll find a link to the amicus in my blog post.
Okay, and let me
but that's why, like, honestly, that's why I think that there's going to be a taxpayer win here, because these are two very influential people. Okay. And for them to write, and it was a short, sweet, articulate, simple, okay, basically, look, this is what the treaty means and why, etc. And when judges are looking for justifiability, simplicity, it's kind of nice to have that in your back pocket, right?
I mean, yeah, I guess it's should have Ivy League professors, everything. I mean, a good thing we do.
Well,
no, and I appreciate it. That's awesome that they put their time into it. That's
okay.
Great. And
Look,
I'm sure
Rosenblum apparently, he has a long history, as I understand. I've never met him, but everything I read about him, he has a long history of being involved in the treaty negotiation process with a number of countries, including Canada. And, for him as a participant in that, to take the position that this is what the treaty means, it's obviously very, very helpful. I mean, you know, it's better than, you know, say John Richardson thinks this or Anthony thinks this. I mean, that's very weighty stuff, right?
All right, a quick story. I was helping a friend of mine defend himself on a restraining order. That he was having a beef with some other guy, and the guy filed a restraining order against him, and it was total harassment. And so there I was in court, and the judge gets up there to speak, and I'm like, oh God, how's this gonna go? Am I gonna be here all day? What's going on? It's like this, my buddy's like, oh my, this sucks. It sucks. The judge gets up there and he's just like infuriated. He goes to the other attorney. He says, I just want to let you know, I was on the committee that wrote this statute. And I want to be very clear here. This is not the type of case we had in mind. Dismissed.
Awesome.
I wish every day was like that.
Yeah.
That was amazing. But yeah, let's get to. We got a lot of. I want to get to some comments here and get you just a little bit more discussion when people got.
Yeah, just before we go to the comments, right?
Yeah.
I want to emphasize again, and if you want to pull that other thing up, we'll go through it like in 1 minute, okay?
Yeah. You bet. Let me get the other.
The reason that this is an issue is not so much the net investment income tax.
We want which is the engineering.
The engineering one.
And
yeah, so how is actively litigating the engineer, and that's what they're trying to do, obviously, okay? All they have to, and this is the point that I'm making, this does not stop with the net investment income tax, right?
Right. Yeah. Right. It's anything.
Yeah, just keep going. Yeah, okay, next.
Meat grinder like
next.
that.
We don't need that at this moment. Next.
All right.
Well, again, that emphasizes the U.S. government position versus, the taxpayer. Amicus means the professors.
What do? You go home and after you argue this piece of turd, you're like, you just turn on the TV,
Well, look, I think, I don't want to be negative on the government lawyer. It's just that, would you want this dumped in your lap?
No.
It's an incredibly difficult, case, and the problem is that she really had no arguments for it at all. It was bad. Okay, but anyway, next. Now, look, let's pause here because this is where I really want to end with my point. Okay, and I think this is so important. The more that I analyze this stuff, the longer I do this, the more I understand that when you look at some tax provision or treaty provision, what does it mean today is only the beginning of the inquiry. Okay, that's looking at the trees. The question is bigger picture. What does this mean down the road? And if the government wins on this, it will be catastrophic for American citizens, not only, but particularly Americans abroad, because they will be able to essentially deny foreign tax credits for anything. Now, the government lawyer was asked during the hearing, and one of the judges picked up on that and said, well, what's to prevent them from denying foreign tax? You know what she said? They would never do that. Only a government lawyer could say something like that.
Oh, she just wanted to go home, I think. She's like,
I would never
say words, and then we're going to end this, and then I'm going to go on my next case, okay? Because I have other cases.
Anyway, so there we go.
Look at that unlocked future of red. The government likes that. That's amazing. Guaranteed treaty protection's over because it's only as good. And I think here's a good comment here. And I think this is, what Rob. Thank you so much for joining us today, Rob. Rob's right here. This is where are we here? We have it right here. Let me go up. We have, well, actually, I don't know if this is an adhesion contract. I wouldn't call it an adhesion contract, which is true. There's other adhesion contracts, and I would say that's more of our sort of our own tax return is that. Maybe that's what you're talking about.
Well, the government is arguing that's an adhesion contract. The government's arguing that it's not. That's the point. The proper interpretation is that it's not an adhesion contract.
Yeah.
Certainly the FATCA IGAs are adhesion contracts, and they're trying to interpret this as though it's a FATCA IGA, basically, right?
Yeah, and maybe Rob's point here, hey, look, you're better, being double taxated than bombed, right? Hey.
Well, I mean, this is the treaty equivalent, right, of of a military strike. It really is.
Yeah. Oh, geez. Andy says we're totally missing the argument. Oh boy. All right. Well, actually, and Andy, I don't want, because that part is sort of what I'm trying to set up, because we are looking at this because I think there's a lot of things that I'm sort of thinking about in the back of my head.
So we're talking about the interpretation of the tax treaties. That's what we're talking about here.
Yeah, and I think we're going. There's a lot of other things that I think that terrify foreign income. Hey, good morning, David. Great to see you. And the first tax treaty? No, the first tax treaty was with Britain, Great Britain, of course. Hey, we went to war for independence against you, so therefore, let's get to that tax treaty. That's actually the first one. Now, yeah, this is what we're saying. It's like, well, what comes? This would be more of the argument. I think we would have. I think there's a totally separate argument on sort of how should treaties be interpreted. That's a different topic than what this is. Our topic isn't, this is not. I'm not discussing like, okay, how under how under the text of the Constitution in our maximum common law, how should treaties be interpreted? That's not what I'm discussing today, Andy. But more like, how are we dealing with the status quo? And sort of what we're going with. But I guess your point would be, well, Anthony, Bruin is the status quo now. Okay, I hear you. All right, I hear you in my head. We'll get to that though. Let me see here. And I'm just saying that because we are getting out of time here. Treaties do not historically include tax powers.
Well, that's absolutely true, but that has nothing to do with this issue. Treaties do not create taxation, right? I mean, in and of themselves, right? I mean, they just provide mechanisms for dealing with existing taxation. But again, what we're talking about here is the interpretation of a specific treaty with or without regard to any constitutional legitimacy or anything else. That's what the focus of this is. Treaties do not create taxes.
Mm-hmm. All right. All right, let's hear. Andy's getting into this here. You don't actually study all the counterfeit money types to identify the real money. Oh, I just went through this rabbit hole yesterday. Oh my God, yes. So here's a rabbit hole that I went down yesterday. Basically on the common law definition of money. Okay. And the common law definition of money is it's gold or silver, or a gold or silver certificate. That's what it is. So when the government has the power to regulate money, that's what it's doing. So the question becomes, well, where does it happen that the government invents this power to have a bank? And that's where we get to McCullough versus Maryland, where the Article 3 court interprets an Article 1 power to say, well, look, there's penumbras. There's penumbras to these express rights, and one of those penumbras of these express limited rights is unlimited rights if it feels good. And so that's where we get that's where we sort of get their toe in here to now define something other than money. Now, why I'm bringing it up in particular for this show is that if you remember 31 USC 5314, the FBAR authorizing statute regulates monetary instruments. Regulates monetary instruments as well as money. Which is, a bank account isn't money. A foreign bank account isn't a monetary instrument. And even, and then what's the real definition of money? And that's one thing that we have to get to the fun thing. And that's part of how these statutory things expand and redefine things to what they are explicitly not. That money is defined very, very clearly. And then the courts go around every which way to say it actually means not that. Well, in that, but also exactly not that. And in fact, now Congress regulates no money whatsoever. There's not any money whatsoever. Maybe gold, or maybe the gold and silver reserves at the U.S. Mint. I don't know. Maybe it's some, but that doesn't regulate any money. And that's how well the Supreme Court is good. That's how efficient the Supreme Court is at interpreting things. And that's what we get to these things like this: elimination of double taxation. Well, why are we even here? Why are we even? This shouldn't even be a case. We have a treaty that says elimination of double taxation, and now the government's like, yeah, but it really doesn't mean that, because we've interpreted every which way, just like the rest of our laws that we do. And so we interpret these things away. And again, the word games, and that's all we end up with. Oh yeah, Rob. All right, here it is. This is actually, yep, Rob. This is what a dollar is, per the 1792 Coinage Act, which has never been repealed. This is actually true. Yeah, that's actually true. We got to wrap up here, and I'm just really thrilled about today's podcast here, and I want to thank it. But it kind of does show us where I kind of want to take the discussion on some of these things, about some of the, more looking at the fundamentals behind these treaties. And exactly, it's like, look, I think, I've gone and done some treaty interpretation research, and guess what I found? A lot of doctrines. A lot of doctrines and treaty interpretation. So I wonder really what is the way to do that. And maybe that's something to handle, where we could cover some of these things, because we have the application of various judicial interpretations of what. But that's the thing. These judicial structures always work to frustrate the very explicit purpose of these documents. And it's just these word games, and they're taken seriously. And that's really what I find obnoxious. It's just word games, and they're given credibility. So that's what we're here to fight. So we got to go. So I want to go over to Keith. So Keith, I hope, so Keith, now what's going to be your takeaway from this, Keith? What's going to be your takeaway? Oh, I might have lost Keith. Let's see. Is he here? Yeah. Anyway, we might have lost Keith's audio, but I'll just give him a shout out. So Keith, I want to again thank Keith for joining us, because he is one. These are hard issues for people who want to get into. Now, we have a dedicated following here. We like it. We love you guys. But it's a hard issue for people to get to. And so Keith is really incredible at getting the word out to the lay people.
Yeah, I'm
there
here.
He is. Oh, Keith. Yeah. So what's your takeaway from this?
My takeaway from this is you just got to be very careful as an American overseas on the decisions that you make, because whatever decision you take today can have some serious consequences moving forward. And here's the thing, is that, how do I put this? Is that if you are already in the tax system as an American overseas, or if you're not, and you're deciding to get into the U.S. tax system, you are going to be at the mercy of any changes in U.S. tax law, ergo what your guys are talking about today.
Yeah.
So you could really be screwed moving forward. So you have to think long and hard about all of your options before you do anything. Absolutely. That's my takeaway.
Right on. And Keith really is great at helping people make those options. And you reach out to Keith. You're wondering if you should enter the system, whether you should renounce, maybe. Reach out, and also if you're receiving an inheritance from the U.S., it's a big reason why people reach out to Keith. So you can reach out to him at US_overseas_advocate@outlook.com. And of course, you can check out his Facebook group, American Expatriates, as well. And also, this is where you are. I think that my advice for people, this is usually my conversations when I meet with new clients, they go one or two ways. It's either renounce your U.S. citizenship or become a U.S. citizen. It's an ironic world we live in. But if you are thinking about renouncing, it is something going on, because these are just sort of who wants to deal with this uncertainty. And for a lot of people, it's not necessarily the money, it's the uncertainty and grief. They just want resolution. So if you are, your final resolution can be upgrading you could be upgrading your citizenship to that 4-door status, which gives you so much more flexibility than the 2-door status by renouncing your U.S. citizenship.
And if I may do another plug for you, Anthony, is that because you're in the States, is that people who are contemplating becoming a U.S. citizen, it might be good for them to contact you so they can give you a layout of what their future is going to be.
Because if you're planning on leaving the U.S. at some point, they need to really sit down with somebody and look at all the different possibilities.
What's going on here? That was going to be my plug for myself.
Oh.
Thank you, Keith. I appreciate that. No, exactly.
Well,
That's what it's going to do. Is like, hey, look, you're thinking about renouncing. Reach out to John. Here's his email. And then if you are thinking about becoming an American, and really, I've had calls that have turned where I want to renounce. Oh, actually, I guess I want to go back to the U.S. and maybe bring my wife. That's what it goes with.
Right.
So it's really a fascinating thing. And when I'm going over some of the tax strategies that I have in the U.S. With my non-American clients.
But Anthony, also people in the United States who are looking to get a green card or to become a naturalized citizen, they should sit down with you.
Yep, absolutely. That's something we do. We offer pre-immigration planning. I was actually working on my website yesterday, and that was actually the page. So when you're saying this, I'm laughing because I was on the website. I'm like, oh yeah, I need to have a page for pre-immigration planning. And so thank you very much, Keith. So I guess I was on the right track. So thank you very much for that. I appreciate that. I do want to just give a shout out to John. And if you are thinking about reaching out to him at citizenshipsolutions@pro.mail.com. And, John is just really, we got to thank for his efforts in these. And he provides a lot of the intellectual background to the statutory interpretation of a lot of the things. And I think that's where, John's keen and analysis always sort of makes you want to go a little bit deeper. And then when you go deeper, boy, you can't unsee what you see. That's for sure. And it might change you forever, as I think. So with that, John, Keith, I want to thank you all. John, wait, John, do you have final words? Because you might have another gem here. And I want to get you.
No, I don't really have much else to say on this, other than that this is a huge, huge issue, and it's fascinating to me how the discussion about this is framing this as a net investment income tax issue. It includes that, but it's far bigger.
It's far bigger than just the small thing. That's right. All right, beautiful. All right, guys, this is Anthony Parent for IRSMedic. Thanks so much for joining us today. See you next time.